Welcome to the Future of Resolution, Miles Mediation and Arbitration's podcast. In this episode, Miles neutral Matt Thiry sits down with Kwende Jones to discuss the value of civility and professionalism in litigation. Kwende is a partner at Burr Forman in Atlanta.
Well, thank you for joining us for this episode of The Future of Resolution. With me today is Kwende Jones. He's a partner at the law firm of Burr Forman. His practice focuses on business litigation and lender litigation matters. Kwende and I go back quite a ways. Welcome, Kwende.
Hey, thank you, Matt. Thank you for having me.
So you and I had gotten together and talked about, hey, what would make a good podcast episode for litigators? And we came down to basically our origin story, which is going to be an interesting story later on, but civility and professionalism within litigation. So let's start off, Kwende, by identifying the problem. So what's the problem and why is this even something we want to discuss?
There are several problems that come to mind with civility, and they all center around the lack thereof. The legal profession is the one that is based on civility, especially between counsel. And the trend that I've seen more recently is that lawyers take a battle position. And what I mean by that is instead of looking for ways to compromise or looking for solutions, they're looking for ways to fight. And why that is, especially with litigators, it's become kind of a combat sport. It is something where there's a winner and a loser. And whenever you start talking winning and losing, the psychological advantages, disadvantages, playing psychological games, just being uncivil. Those tend to be the trends versus our experience, which we'll go into a little bit later, of lawyers being civil with each other, agreeing to disagree, and recognizing that we're paid to think differently when we're on the opposite sides of the V.
Yeah, I agree, Kwende, and I think that a lot of this comes back to attorneys getting a little bit too personally involved in their client's matter, becoming the client instead of being the lawyer representing the client's interest. They kind of own it instead of work with it. And one of the things I think that is often missed in this is the additional costs associated with that type of litigation. And would you agree with me that in those cases, typically the bills that go to clients are higher than they are where you have attorneys that can work together on a more civil basis?
I completely agree. And in fact, I tell my clients sometimes when we are on the verge of settlement that this isn't in my best interest. The settlement is in your best interest. It's in my personal best interest to keep this litigation going on and on. So I completely agree that one of the issues is the attorneys getting personally involved and making personal attacks. And some, I think, even do it to increase the fees. That's the goal. I don't want to accuse anyone of that, but I certainly have been in situations where it seemed that the other side, their whole intention was to fight, regardless of whether that was the best interest for their clients.
Yeah, Kwende, I agree. Two things in addition to that. I think it takes a lot more time to litigate a case when you're dealing with all of these ancillary arguments between counsel that have nothing to do with the center focus of the case. And I also think that these situations where you have counsel that are really battling it out just to battle, that aren't really focused on the case, it makes it very difficult for the client to get to a position where they can reach resolution.
I completely agree. I completely agree.
And then you get to the other side of this, which is how does this impact lawyers? And, you and I have been litigating for quite some time, and, we've seen what happens to lawyers, particularly litigators over time as it is without this kind of aspect of the practice. But when you add in this type of situation to the battle where you have counsel on the other side that's making it pretty much an impossible personal attack to have to wade through, wouldn't you agree that that just adds to the burnout?
I certainly agree. There are attorneys who I have to get geared up to have a phone call with. I see their number that comes across on the caller ID, And if I'm not in the right mental state, I can't take that call. And we're practicing law is a very stressful profession. Being litigators is even more stressful, in my opinion, because typically there's another lawyer who's just as skilled, just as smart, that wants the exact opposite of what you want. If you're doing real estate closings, or if you're a corporate lawyer and you're doing deals, the lawyers typically have the same objective. In litigation, our objectives couldn't be further opposite of each other. And so there's already a tense aspect to that and a stressful aspect to that. But you add in, personal attacks, just being uncivil. And I hate using that word, but I think it's the best way to describe the behavior. Arguing over things that really don't have any real merit or really any bearing on the outcome of the case. It only raises the stress level. And I completely agree. It just increases the amount of burnout, and you're going to get there a lot faster.
And you not only burning out, but losing faith in the system itself, where you feel like, what good is a litigator doing for the client if they're having to spend all of this additional time and money dealing with the sideshow instead of the case itself. So
I agree.
Yeah, it's hard. And when you talk to younger lawyers that are experiencing this, it's one of those things where you're trying to explain to them, that not everyone is this way, and this is not the way you should engage in the practice of law. So it creates a challenge when you're trying to train someone also.
No, I agree, and I think training has a lot to do with it. I've had the great fortune of working with multiple lawyers, all with different personalities and all with different styles. And I can honestly say that there are some lawyers out there who feed off the combative nature of litigation. They have to make the other side their enemy. That's where they get their energy from, and it works for them. Now, it's not me. It doesn't work for me. And I had like I said, the fortune of working with people with different styles, and I liked it much better when the lawyers, especially the lawyers that were my mentors, when I would help them on cases, that had a style that allowed for the lawyers to get along. Some of the best times that I've had have been the drinks that I've had with opposing counsel after we've had an intense oral argument. And we get and we fight and we argue, and then afterwards we shake hands and we have a drink. And it's just nice. It's a breath of fresh air. It's just reassuring because it lets you know that the profession is not completely lost. It seems to be headed in a bad direction, but it's not completely lost when you find someone who has that same mindset.
Yeah, Kwende, I've seen it more so, and I mean, I agree with you. I think there are lawyers of all ages and that kind of engage in that let's make it as miserable as possible approach. But I have seen more of that in the younger generation of lawyers lately, and I don't know if that's something that you've seen as well, but it seems to be I've got something to prove, or I'm trying to make a name for myself, or I'm trying to impress my client or my supervising partner or whatever it is. So I'm going to engage in this inflammatory practice and make this as hostile as possible.
Matt, that my experience has been is across the board. Usually the people who I have the most issues with are older than me or right around my age.
Okay.
The younger lawyers tend to, well, I take that back because I have had some of the younger ones too. So maybe it does go kind of across the board. But the real issue has always been with me, the older attorneys. But I take your observation, and maybe it has a lot to do with training and, like you said, trying to impress their colleagues. I don't know. That's a good point.
Well, I think we both have said it. I think it spans across. They're scorched earth lawyers in the litigation arena, probably from day one to day retirement. So
that's right.
One of the things I find interesting is dealing with client expectations on how you interact with opposing counsel. That's always a tricky situation, and it's always been a tricky situation because clients seem to, This is a broad stroke kind of concept, so I don't necessarily mean to imply that all clients are this way, but a lot of clients feel that if you're chummy with opposing counsel, then you're either not representing their interests zealously, or you're going to sell them out at some point in time. How have you had to deal with that?
Yeah, and I've had clients like that. What I like to do with every client relationship, especially early on, is I tell people exactly how I operate with opposing counsel. And I kind of set out parameters. These are decisions that are client decisions. And ultimately, whether or not you grant an extension is a client decision. But I just explain to the clients, hey, it's good form. It's good nature that if someone calls and asks for an extension and the extension is reasonable and the reason that they need the extension is reasonable, we should grant the extension. And most of the time, the clients are understanding because I've set that parameter and I've set that expectation in advance as to how I deal with opposing counsel. In the situations where we have the clients that kind of take the position, don't be chummy, no extensions, then I go down the road of trying to explain to the clients the ramifications or the possible ramifications of not granting a reasonable extension. And some of those ramifications or consequences could be if this is a reasonable request and they have to file a motion that we may have to explain to the court why we didn't grant this reasonable extension, which could put us on the bad side of the judge. And ultimately, you never want to get on the bad side of a judge or appear unreasonable to the judge because it may affect future rulings. And so typically in those situations, that's worked when I believe that an extension should be granted. And I don't grant all extensions. It's not a runaway here as far as granting those requests. But if they're reasonable and warranted, I try my very best to make the client understand that this is a good thing for us to do and this could help us in the long run.
Yeah, clients also have to understand that a 14-day extension in the grand scheme of the case is really not any measurable amount of time. So you're not really pushing them down the road off into infinity because you gave a 14-day extension on discovery, for example.
That's right. And I also tell them this. I said, well, as soon as we say no to an extension, we're not getting any extensions either. So we better be on top of our document production. We better be on top of all of our discovery responses. And clients know how sometimes things can go haywire, and deadlines can run up on you pretty quickly. And that's worked as well. Say, hey, if we were in their position, we needed an extension, they're not going to give us one if we don't grant this courtesy now. And that's kind of how I explain it. It's a courtesy. It's a professional courtesy. If someone's taking advantage of it, then it's no longer a professional courtesy, and we don't give it. But as long as it's reasonable, it's warranted, I consider it to be a professional courtesy, and more often than not will grant those requests.
Yeah, I have a very similar approach with that as well, Kwende. One of the things that I often have to tell clients at the beginning of a representation is, look, I'm going to be vigorously fighting for your side of this case, whether it be in the correspondence with counsel, whether it be in motions filed with the court or an appearance at court. That doesn't mean that I have to take a sword and go after opposing counsel, because that's not our target. Our target's not opposing counsel. Our target's the facts of this case and the law that applies to this case. And you don't want me distracted chasing a shiny object off in the corner when really I need to be focused on winning your case. And that goes two ways. One, if I shake hands with opposing counsel in court, or I talk friendly to them and ask them how their family's doing, or I want to have lunch or go out for a drink and you see us out somewhere, that's not me selling you out. That's me just being friendly with people that I am in a profession with, that I see on a regular basis. And you can rest assured that when it comes time for me to draw the sword and go fight for you in court, that's not going to impact it. Kwende and I can be friends, but if we go into a courtroom, our friendship's not changing that case.
That's right. and we've seen it. We've lived it. And we're still friends now. And so I completely agree. One thing that I would add to that about just explaining to the client that showing or having a good rapport with opposing counsel could be beneficial. I always look for ways to resolve a case. And if because I'm always trying to define what success is for a client. And it's rare in my experience that success or the definition of success in a particular case for a client is take it all the way to trial no matter what. That's rarely the outcome that would be successful for the client. And so settlement is something that we always discuss, that we always want to at least try to pursue. And if we're going to have real heartfelt settlement negotiations, you have to have a rapport with opposing counsel. And the only way to develop that rapport is to have conversations, to be able to talk, to be able to ask about family, and to be able to be cordial. And if you can't do that, it's very, very tough to settle a case because there has to be a level of trust between the lawyers, especially when you're talking about settlement, that you're going to do or your client's going to do what you say your client's going to do. And if you don't have that trust and you don't have that rapport, it makes it really difficult. And so I think that just adds on to what you were discussing.
Yeah, I think when you're looking at resolution, whether it be through negotiations over the phone or via email or mediation, having some rapport with opposing counsel is a pretty critical piece to that. If you can't at least baseline trust, and I'm not saying wholeheartedly full buy-in on every single word opposing counsel gives you. I'm not saying give them full trust, but if you can't have at least like a borderline kind of baseline feeling that they're going to be honest with you and deal with you fairly, it's really hard to have that conversation about how do you reach a resolution in this case, because they're never really looking for the actual resolution. They're looking to pull one over on you, and you kind of pick up on it pretty quickly.
That's right. And that's even more so when the clients don't trust each other.
Right.
And a lot of times when you're in litigation, the clients don't trust each other. And so you have to have some rapport with counsel.
And you mentioned earlier about how with an extension, for example, you may not grant that reasonable request, find yourself in front of a judge, and then have other consequences associated with that. And I think one of the things that's missing from a lot of the client understanding is that judges pick up on things. They're not just reading the brief, and that's the extent of what they see. They see the tone of what's going on. They can see from the filings how counsel's approaching the case. You and I both know what it looks like when you have the Rambo litigator filing, 12,000 motions, half of which mean nothing, just to file them. Judges pick up on that. You're taking up their resources, and you're wasting their time with things that they don't want to deal with. And as you mentioned, I don't know that a judge necessarily rules differently on the facts and the law based on that. But where I think it comes into play is when you have one of these judgment calls where you're kind of, this could go either way, and I've got to weigh the evidence and make a decision on which one of these two I think is a better approach. I think you lose on those situations when you've taken the unreasonable approach throughout the litigation.
No, I agree. And especially in the discovery context, when there is a discovery dispute, and those can go either way based on the particular judge, the particular day. If you have proven yourself, and it's not just this particular case, I think what clients don't realize is we're in front of the same judges over and over again. And so you develop a track record. And I can remember being in front of someone or having opposing counsel who always filed discovery motions, always filed motions to compel, no matter what your responses were, no matter what your interrogatory responses or your production was in that particular case, they're always going to file that. And they had that reputation. And when we went for the hearing, it was obvious that the judge knew the other lawyer, knew the lawyer's tactics, and had enough. And while I'm going in thinking I'm going to have to go and explain that this is frivolous and these motions shouldn't have been filed and we've done everything proper throughout discovery, the judge already knew that. Now, it's bad for that particular lawyer if we hadn't done what we were supposed to do, because the lawyer lost all of credibility with that particular judge. So I think it matters, especially in that context. And that's where the civility, I think, really, really shows itself, is when you're trying to resolve discovery disputes, because we both know there are legitimate discovery disputes where you believe in your position, you believe either a document is not something that should be produced, the other side disagrees, and you have to work through those issues. And if you bring those to the court and you're not taking a reasonable position, yeah, I think it comes back to bite you.
Right, and clients don't necessarily know going into it that their attorney has the history of filing those and the reputation with the court. So it's really an interesting thing for a client who signs on not knowing that and then gets the bad side of that aspect.
That's right.
We've talked about the downsides of civility and professionalism, and we've talked about what we've experienced throughout our career a little bit. But I don't want to be overly negative here. I think there's definitely a lot of good folks that do what we do also, and we've had some experiences with that. And I think really that's how you and I got to know each other, Kwende.
Yep.
You and I was trying to think before we started recording today how long ago it's been. It's got to be at least 12 years at this point in time.
Maybe more than that.
Yeah.
I think we were in our old building, and we've been in this building maybe 14 years. Okay. So it's been a while.
Yeah, so a long time ago, Kwende and I had a case where we were opposing counsel, federal court case. So we got together at Burr Forman for the discovery conference early on in the situation. I don't know what was on my mind that day, and I was trying to think back, and obviously I'm having a hard time remembering yesterday at this point in time, let alone what happened 12 or 14 years ago. But I was thinking, what was it that was on my mind? Because I remember sitting down at the conference room with you, and talking about this case. And I basically just laid it out. I said, hey, Kwende, our clients hate each other. And they really did. I remember that part of the case pretty well.
Yep.
Our clients hate each other. And we're going to have a lot of battles in this case. But this does not have to be Matt versus Kwende or Kwende versus Matt. Let's just keep it client versus client. We'll do our jobs, but there's no reason for us to go after each other. And I don't know that I had ever bluntly stated that in those terms before, but I'm glad I did, because it went really well with us. And I think it set the stage for that case, which we did battle out for quite some time before it resolved. But not only set the stage for that case, but it set the stage for, you and I becoming long-term friends out of the situation as well.
No, I remember. I agree. I remember that because it was so refreshing, because that's how I want to handle it. I tell people all the time, we are paid to think differently. I am on the other side of the V. I don't expect you to just agree with all of my positions or all of my arguments. But luckily, we've got a judge who can determine who wins the argument. So we don't have to go back and forth. We've got a referee to figure that out. And in our particular instance, it was refreshing because not only did our clients hate each other, they didn't trust each other. They couldn't be in the same room with each other. And it made it very, very difficult. If we weren't able to break those barriers early on, we could have got caught up in long-term litigation, which would have been great for both of our respective firms. Horrible for the clients. And probably we wouldn't be sitting here now putting together the world's greatest podcast.
That's right.
And so I thank you for extending that hand, because it takes a lot of trust, because I think, as you said earlier, the problem with civility is that you have to trust that the other person is not feeding you BS. And you've got to have that baseline trust. And you had to have a level of trust that, hey, look, our clients hate each other. Let's just work through this. And if I took advantage of that, things would have went south very quickly. But it was the way I like to operate. It was the way I like to practice law. I never dreaded answering your call. I knew we weren't going to agree on everything.
or
I
anything.
knew we
most
were
of the
going to
time.
argue, but it wasn't that I saw your number come across and I said, "Oh God, I gotta deal with this guy." No, it was never that, because we had a level of uh, civility. I hate using that word over and over again. I know it's the podcast topic, but we had a level of civility to, you know what, we're not going to agree. We'll let the judge decide that issue. But hey, let me tell you my points here. This is where I think, we have some strong arguments. And ultimately, going back and forth, we were able to get the case resolved, which to our clients' benefit, both of them. And I think that was a good thing. And like you said, you got a good friendship out of it as well. And there are more experiences like that. And I agree with you. I don't want to come across negative, thinking that every experience with every lawyer is bad. The bad ones tend to stay with you more because they require so much energy. But I tell people all the time, I say, hey, I appreciate how you litigated. I mean, we argued when we had to argue. We compromised where we could compromise, and we were cordial with each other. And I appreciate that. And every time I deal with someone in a case, if that's how I feel, I tell them. And usually it's repeated back. And carrying on our tradition, try to schedule a lunch or drinks to see, hey, this could be another friend. I might be doing another podcast 5 years from now with someone. And so it just feels good, man. It makes the day better. I like to laugh. I like to have fun. I'm a kind of a laid back person. But at the same time, I can be a jerk just like everyone else. I don't like to be, but I can. I think all lawyers can. I'd much rather be the nice guy, and we can argue when we need to, but we don't have to argue all the time about things that don't matter. And that's one of the things I appreciated, the way you handled that case, and your colleague as well. I don't want to leave Mina out, just in case he listens. I want to shout him out.
That's right.
Because it was across the board. It was across the board.
It was, and it was reciprocated well. And I think that we both, one thing I know about that case, thinking back, I don't think there was a single procedural issue that we had to deal with at all in that case. There was the only disputes we had really were, here are the facts and here's the applicable law, and let's go slug it out on these issues here. But we did not have one time in that case where you and I got squared off on a procedural issue.
No, I agree. When I make a legitimate argument and it's legitimate, and you try to just undermine it by calling it frivolous and not accepting it, just because you disagree with it doesn't make it a frivolous argument. And I think lawyers just use that term way too much. It's meritless. It's just way too much. And one of the things, we had a disagreement as to how the law applied to the facts. But you're right. No procedural issues, no discovery issues. Those things went along smoothly. I think the court realized it. And ultimately, and I'd love to get your thoughts on this if you can remember, I think the fact that we got along well helped the clients kind of see past some of their differences and kind of help ease the tension, because there was no tension between us. And so when the clients see that, they still may hate each other, but it's like, well, wait a minute, this doesn't have to be a death match.
Yeah, it's interesting you say that, because I see that as well when I look back at this, and I see that, like, what comes to mind when you said that was, like, for example, your client came to our office for a deposition, and he was smiling and in a good spirit. I mean, he didn't look at us as though we were there to skewer him with some misdeeds or mistrust. He knew that we were there and we were representing our particular client, but he didn't look at us as though we were mortal enemies and we needed to go out in the garage and slug it out after the deposition was over.
Right, and that's another part of I think being civil as well, is explaining that to your clients and having them go into, like you say, a deposition, just knowing that these guys are doing their jobs. They're going to be asking you some questions. You can be difficult, and we can be here the full 8 hours that's allotted, or you can answer the questions. We have our position. We believe in our position. We're not trying to hide anything. Answer the questions. If they ask something that's inappropriate, let me deal with it. And we had that discussion and didn't have any issues. But I think that also goes to the civility part. Educating your clients that the lawyers aren't necessarily the enemy. And I tell people this too on the other side. I'm often, when I'm representing my client, because I represent a lot of financial institutions, when I'm representing the client, I am your voice to the client. If you tell me a position, I'm your voice. When I tell lawyers all the time, you're the advocate for your client, I'm the advocate for mine. But when you tell me something and you want me to take it to them, man, it helps if we can get along, because I'm the advocate for your client to my client if there's going to be a resolution. So, I think I think it all blends together. It makes the profession better. I think it makes your time in the profession more enjoyable. And it doesn't take away, like you say, it doesn't take away from zealously representing your client. It just allows you to do it and not be a jerk while you're doing it. And you can take positions, and listen, you and I have argued and we've had heated discussions, but they've never got personal. And they've always ended with kind words. Well, we're going to disagree. Hope you have a good week. I'll talk to you next week. And like I said, and we pick up where we left off.
Yeah, I think that's a great point. And it goes as well to the concept of having a good lawyer on the other side of a case. I've had clients come in, they're like, oh no, man, they've got a good lawyer on the other side of this case. And I'm like, thank God. I mean, listen, I'm glad they've got a good lawyer on the other side of this case. Usually cases go a lot better when two good lawyers are working them. I mean, I'm all for having good lawyers on the other side of the case.
No, I agree. I agree.
You mentioned my former colleague who was a part of that case, and I think it's fair to say that we kind of put together a small group that got together after that case was over, and we've kind of remained in good touch. You had a colleague that was a friend of his, and even though she's no longer with your firm and he and I are no longer at the same firm, that group still has a continued history of getting together and looking forward to the next get together. So these things last. It's not just a flash in the pan. When you have a good relationship with counsel, it should go on.
I agree. And I want us to follow through on our civility club idea. We always talk about it. It's going to be an invitation only civility club for lawyers. You have to be invited by a member who has been opposing counsel or recommended from someone. We got to get that off the ground.
Yeah, I mean, it's definitely in need in these days for sure. So, well, I wanted to thank you again, Kwende. I mean, you and I, like I said, I'm very happy that our case went the way it did, obviously many years ago. I'm also very happy that you and I take a similar approach to the way the practice of law should be. And that is, try to get along with opposing counsel. There's no need to throw bombs where bombs do not need to be thrown. That doesn't mean you're going to lay down and get stomped on by opposing counsel, but you're not looking to start fights where they don't need to be. So, I mean, I've always appreciated that about you. I've always talked extremely well about you to other lawyers in town. When your name comes up, I always tell them our story of how things went. So I really appreciate it. I appreciate you taking the time to be on the Future of Resolution podcast with me today. It's a great honor to have you with me, and I look forward to having an opportunity after this world event of COVID-19 starts to burn down a little bit, getting back together with the band and grabbing a lunch.
Thank you so much. I appreciate you inviting me on. Appreciate the work that you do, and echo all of the thoughts that you said regarding just being civil, cordial. I appreciated the way you handled that case, and thanks again for having me.
Yeah, Kwende, thank you. Talk to you soon, buddy.
All right, thanks.
You've been listening to The Future of Resolution, the podcast. You can follow The Future of Resolution on Miles Mediation and Arbitration's Instagram, Twitter, and Facebook, If you haven't yet, go to Apple Podcast, Stitcher, Spotify, and subscribe, rate, or review this podcast. Join us soon for another interesting discussion. Thank you for listening.